and it's binding on the real estate. And it affects the title. It affects the title. Now, what do we mean when we say we have good title? If I say that that property has good title, what do we mean by that? There's no encumbrances. There's no claims against that, no charges, no liability, maybe no mortgages against that. So that's why encumbrances affect title. So liens are financial. So you have to know the different types. So liens are financial charges against property. They provide security for a debt or an obligation of the owner. The lien holder is the creditor, has the right to have the debt paid out of the debtor's property. The debt can be paid from the proceeds of a court order sale. So, is that signing sheet? Go through and see who we're missing. Maybe just put their names on it, squeeze them in there.
Do you have a highlighter I can use? Do you have a highlighter I can use, Tom?
Excuse me, honey?
Do you have a highlighter I can use?
Yeah.
I don't want to take your. Is it
I
yours?
know I have like 4 or 5.
Okay, thank you. Forgot mine. Never mind. Never mind.
Did you get one?
Yes.
So a lien is a financial charge. If I go to buy a house and I need to get a mortgage on it, I go to the bank, they lend me the money, I buy the house, and they put a lien against it. Now, it can be paid from the proceeds of court order sale. So if you get a mortgage, really you're not getting a mortgage, you're giving a mortgage. But we're going to get into that later. If you give a mortgage to the bank and they have a lien against your property and you don't pay, they can go to court and they can ask the courts to sell the property, and then they can take the proceeds and pay the loan off. And then they boot the person out. Deed restrictions. They're private agreements that affect the use of the land. Binding on subsequent owners. We talked about these. They run with the land. They're enforced by private court actions. Covenants, conditions, and restrictions. They're filed in a public courthouse, and usually they're on a subdivision. Is that plat underneath there, Andrea?
It is.
Are we started here?
Yeah.
Okay. So if an encumbrance is binding on real estate and affects title, wouldn't a deed restriction be something that's affecting the title of that property? Yeah, right. Because if you have two properties and one doesn't have any deed restrictions and one does have a deed restriction that you can't put a mobile home on it, remember we talked about that? Then that's affecting that property. It's affecting it. So a deed restriction is also. Can you put her on top of me? And I think I have one. I have an appointment with her on the 31st. Easements. They can affect the property. Okay, the right to use the land of another for a particular purpose. It may exist in any portion of real estate. It can affect the airspace. So let's say there's an airport, Ross Draver Airport, right down the road. Okay, and I have my house here, and the airport's over there, and the airport's good. I'm right in the line of the runway. The airport may come to me and say, "Hey, I need an easement to go over your airspace, so that the planes can land." Now, why, Lauren, would they need an easement?
That's under your ownership.
It's under my ownership, because if I own that land, can't I build a 100-story building? Well, if I build a 100-story building, how are they going to land the planes on the runway? Yeah, if you could follow up on it and get everybody to sign in when they come in. They may exist on any portion of the real estate. They can be right-of-ways across the land. So How many times have you seen power lines going through somebody's property? A sewer line, a water line. Those are all easements, and they affect title. They affect title. Now, when I say they affect title, Samantha, what do I mean by that? Again, it goes with land. So if this is one parcel here, and this is another parcel, and this parcel right here has no encumbrances against it at all, no easements, no anything, could have a mortgage. Let's say it does have a mortgage, and that's it. And then this land, this piece right here has a mortgage. So either one of these properties, if you sell them, you have to pay the mortgage off, right? But this land here also has a right of way for a gas line that runs through it, or airspace for an airport. So that would affect the title here, because the title is not 100% free clear because of that easement. Does that make sense? I don't know if that's the best way to explain it, but you can have access to underground rights, gas rights. Apparent easement. Annexed to the ownership of a parcel. It allows the owner to use of a neighbor's land. Okay. Individual interest in the limited right of use of the land of another. Benefits an individual or company's interest. So let's say here's the main road, right here. Here's the main road. And here's two lots. This lot right here and Seneca's lot, okay? But Seneca's lot's not on the main road. So how does Seneca get back to her lot? Well, this property right here can give an easement so that they can put a driveway in to get to this back lot, okay? And that's a pertinent easement. See if I can get this video working.
Pass your real estate exam with PrepAgent.
There's my buddy.
Remember, keep it concise and keep it simple.
Did anybody go online, YouTube or Google PrepAgent and look at any of his videos? Did you? Were they helpful?
Oh,
Yeah. I mean, you know, you're at home, you're going over a section, you don't understand it completely, Sheila. You can go to Google that, you go to PrepAgent, or there's a lot of other companies too that have videos, and then you can listen to a video, maybe it'll help explain it a little bit more in layman terms, you know? So, listen, my job here is not to teach you all this material, and you come here, and when I'm done bullshitting and talking, you can pass this test. My job, Lauren, is to help you pass the test by giving you the right tools. Does that make sense? And this is a good tool to use. This is a good tool. I use it for teaching.
An easement is a right held by one person to use the land of another for a specified purpose, such as access to a property. In talking about easement, you'll hear the terms ingress, which means to enter, and egress, which means to exit.
You need to know those two terms.
And a pertinent easement involves two properties owned by two different owners. The two properties involved, here the terms ingress, which means to enter.
So you need to know what ingress means. Write it down somewhere. That means to enter. Egress is to exit.
And egress, which means to exit. And a pertinent easement involves two properties owned by two different owners. The two properties.
Okay, that's another term. So remember, this is a term test, and I'm really taking my time with this class because we're only on Unit 5, and we're 3 days into it. You know, usually I'm at unit 8 by now, but I'm taking my time because the first part of this book is the meat of this class. And I want you to get this terminology down. So an appurtenant easement is what? What did he just say it was? It's the right to use the land of another, right? That's right. So if I'm a power company and I want to go over this lot, would that be an appurtenant easement? Yes. Because it's the right to use land of another. And then you have the dominant and the servient. So these are 2 lots. Okay? These are 2 lots.
Involved are called the dominant and servient tenement. When you're not sure about who is who, just think about what the 2 words mean. Dominant, they are dominating, they are in charge. Servient, they're serving. So therefore, the servient tenement is serving the dominant tenement's purpose.
Okay. We have an easement going through this lot right here to service Seneca's lot. Is she the dominant or serving? She's the dominant. Why? She's using this property right here to access. She's going over it to access that. Okay. Helpful, Squirrel? The way I'm explaining it?
For tangible terms, the dominant tenement is walking over the servient tenement's property. Very simple. Thinking this way may be confusing sometimes, as the dominant tenement property is typically smaller than the servient tenement property. For example, your property can be landlocked, which means that it has no direct access to a public road. So to access your property from the public road, you must cross someone else's property. That property is now serving your purpose, is now the servient tenement in what is now an pertinent easement. The easement will continue after.
So here's some again, key terms. A pertinent easement is when one person is using the land of another, right? We all got that? So we can answer that one on a test. The dominant tenant is using the land of the servient.
After you and your neighbors sell your properties to others. An easement of pertinent attaches itself to a piece of property. It's said to run with the land, which means that whenever the property is sold, the new owner has the same rights to the use of the easement as the old owner did. Under the statute of frauds law, which exists in some fashion in every state, easements must be in writing to be valid. Another type of easement is called an easement in gross. An easement in gross has no dominant tenement because although there's a property being crossed, there's no property to go to. Typically, easements in gross that you may see are utility companies. For example, the electric company wants to connect lines between 2 poles. They need to cross your property to do this. This would be an easement in gross. A court order creates an easement by necessity to permit someone to gain access to a property. For example, say property owner A sells to buyer B a back portion of a land that neglects to give buyer B an easement for access. If A refuses to give B the easement, B can go to the court and have a pertinent easement created. An easement by prescription is an easement that is created by the actions of one person against the interests of another person. An example may help explain this type of easement. Every night when your neighbor Joe comes home, he drives his car across a corner of your property. How annoying. But the reason doesn't matter. He simply does it. You see him, but never stop him. And he does it for a long time. Eventually you get tired of him driving across your property and you tell him to stop. But he says, no way, I got an easement by prescription. Joe takes the matter to court, and the court agrees with him. Joe now has a permanent easement by prescription across your property. Easements by prescription require a court order as they are a result of a lawsuit. The fact that Joe's actions had persisted for a long period of time came into play. That length of time varies according to which state you're in. You saw Joe cross your property. His use was open and what the lawyers call notorious, meaning it wasn't hidden. In a sense, by not telling Joe to stop sooner, you gave him silent permission to use your property.
So does that make sense? So Seneca doesn't have an easement. to go over Lauren's property. But she drives over it anyway. Every day. Drives over it, goes back, comes back. Lauren doesn't say anything. Lauren doesn't say, hey, stop. Lauren doesn't put a gate up. Lauren doesn't block her from using that. After a period of time, I think in Pennsylvania it could be 21 years, I'm not sure. Is it? Okay. It could be 21 years. She can go to court and say, I want a easement because I've been using it openly and notoriously for 21 years. Lauren never stopped me. So I would like that easement. Now, if Lauren sold that property to Seneca, but she never gave her an easement, maybe even if Lauren didn't sell it to her, but she has the property behind and there's no easement, then she can go to court, okay, and she can ask for an easement by necessity. She could say to the court, hey, listen, man, I own this property behind Lauren. I have no easement. I have no way of getting in and out of it. Can you give me an easement by necessity? Okay. And most of the times, the courts may or may not grant that easement. If there's no other access to it, most of the time they're going to grant that easement.
Crazy, right? So let's talk about how to end easements. Easements can be terminated in several ways, including an agreement or release.
You need to know this.
The person who possesses the easement, known as the dominant tenement, agrees to give it up or release it to the person across whose property the easement exists, the servient tenement. You can also end an easement by merging. A has an easement across B's property. B buys A's property. The easement disappears, as obviously you would not need an easement across your own property. Next, there's abandonment. Simply said, you stop using it. For one reason or another, you stop going to the property. However, unlike a dog, when you abandon an easement, it will cease to exist. With that being said, on a side note, please rescue a dog. Okay, last but not least, the need no longer exists. We discussed before how you could create an easement by necessity. Well, what if that need no longer exists? Well, if you could prove that, then in that case, the easement will not exist either. More great information.
So what do we mean by that the easement would no longer be needed? Okay. Let's say the township comes in and puts a road in, a new road, right here. Seneca now can access this road to access the property, right? She don't need that easement. She could ask, so that's one way for the easement to be dissolved. If both properties join, let's say Seneca buys Ellen's property or vice versa, and now the same owner owns this property and this property. No reason for the easement, right, Chase?
That makes sense.
No. Okay, I'm going real slow here, but is it sinking in, Ellen? Okay. Because there's going to be times where I say, read this chapter, read ahead, and I'm not going to go over a lot of stuff on it. But I think the biggest complaint that I've gotten from Lexi's mother, who happens to be my wife, is that the first several sessions, there was so much information giving that the students got lost, and then they just kind of threw the towel in. So I'm taking my time going real slow, recapping, and then as we get into the click of it, this is only day 3 out of 11. I'm excited. We'll go faster. We'll skip over some stuff, and I'll say, hey, read that chapter at home. Party wall. Does anybody know what a party wall is? No, Lexi, it's not where you party up at the Steeler game against that wall that Paul likes to park. That's not a party wall. What would be, because there is a wall where Paul likes to party. What's a party wall? Look in the book, look it up.
wall between two buildings,
A wall between two
or
buildings,
two properties.
okay, that are owned by different people. Okay, so my mother lives in a condo at Spring Grove, and there's 4 units in these condos. There's 4 units. So let's say this room right here is 1 unit where my mom lives. And then her neighbor Dawn lives in this unit over here. But let's imagine there's no door here. Okay? That's the door to go inside the unit, and this is the door to go inside this unit. Well, this is the wall between the 2 units. And it would be considered a party wall. Okay? Now, the way it works is she owns this part of the wall, and she's giving an easement of this part to Dawn so that he has some rights here. So she can't take that down. Dawn would own this side of the wall, really just the front of it. And then he would give an easement to my mom for this side. So a party wall is an easement that's splitting 2 properties. How many times have you seen townhouses where you see 4 or 5 units all in a straight line? Have you ever seen those? There's a party wall in each one of those. The condos at Spring Grove or Cedar Hills, there's 4 units. The walls between the units are considered party walls. It straddle the boundary lines, and the boundary line would be this wall. So the boundary line probably goes down right down in the middle of this wall, the property line, because the property line can't be that fat, can it? Can the property line be this fat? No. Property line is just a straight line, right? When that surveyor surveys, it's just a straight line. So each property owner owns half of the wall. Each owner has an easement right for the other half for the wall's support. Each pays half of the expenses to maintain the wall. You can have a party driveway. So sometimes we sell houses. So let's say Ellen and Savannah own a house right there, and this is the road right here. Have you ever seen a driveway come up and then it splits off to both? That could be a party driveway where they both own half of the driveway, but they have an easement to use the other half for whatever reason. That's very common. Party walls are very common, and party driveways are very common. And they are a easement, right? Which is a what? Encumbrance. Because doesn't it affect the title? Yes, right? It affects the title. When I say it affects the title, am I losing you a little bit on that? No. It's like a rule almost, ain't it? That affects the title. Or a condition. That's a better word to use, Christine. It's a condition against the title. Creating an easement. Express grant from the owner of a property over which the easement will run. So if Lauren is giving Seneca an easement, she can give in writing. She can say, okay, Seneca, I'm going to give you an easement to cross it. Deed of conveyance by the grantor could be in the deed. So when Seneca bought that property, that easement could have already been in the deed. Easement by necessity, we talked about that. It's created by a court order. Easement by prescription. You take a prescription when you got a headache, right? I take Tylenol when I got a headache. I take Tylenol, Seneca, when I got a headache, right? Well, wouldn't Lauren have a headache if you were driving over her property all the time and she never said nothing? And her and Ellen owned this property, and she said to Ellen, that goddamn Seneca's using the property again. Ellen says, we don't want to make any waves. Let her use it. Right? And the next thing you know, Seneca says, I've been using that thing for 21 years. She goes to court to get a legal easement put in. Ellen, Lauren's going to be taking a title, ain't she? Easement by prescription.
My neighbor does that. He owns a back parcel behind our field. But so he drives his quad and brush hog like through our field to get to his back field to cut it.
Okay.
We just verbally said, yeah, you can do that.
Yeah, I'd put it in writing. I'd have a piece of paper drawn up, and I would give him an easement to use that, and talk to an attorney and have an attorney prepare it. Maybe you could lease that space to him. And every year, if you don't say we're not going to renew the lease, he just can continue to use it. I would do something because you verbally said he can use it. Okay. Let me tell you what verbal is. You can wipe your ass with verbal in real estate. Verbal cost me $13,000 last week. Okay. Had an agent that the seller came to the agent and said, we were already into the transaction. We had a seller disclosure statement that didn't mention there was any problems with the sewer lines. Okay. The seller, a week before closing, came to the agent and said, hey, by the way, that willow tree's roots get into sewer lines, and every once in a while, they plug up. So the agent went over to the buyer and said, Mr. Buyer just told me that there's roots to get into sewer line. The buyer said, don't worry about it. I'm a plumber. I'll take care of it. So we closed the transaction. 3 months later, they sued. They sued the seller and they sued us. And we just had the mediation Friday morning. And we lost the case. So even though we verbally told the buyer, verbal doesn't hold up. What should have the agent done in that case?
Wrote it up.
Should have wrote it up. Should have did something in writing stating that the buyer is aware that the sewer line gets plugged up. Maybe took the seller disclosure statement and amended it and had everybody initial. But verbal don't get you anywhere. We lost that case $13,000. Okay, $13,000. What the mediator said was our responsibility because the agent didn't take the next step and put it in writing. Very easy mistake to make. I didn't blame the agent. But I can tell you this, what are we going to do a slide on next Monday's meeting, Andrea?
Disclosures.
And what happened? What disclosures?
I don't remember what they have to be in writing.
Has to be in writing. Okay. She was looking for her notes. She was looking for her notes. Okay. An easement by prescription in Pennsylvania is 21 years. 21 years. Continuous, adverse, notorious, open. Canoe is the word you can use to remember that. What's easement by condemnation mean? Easement by condemnation. Is it in the back of the book? Seneca?
It says the owner that's affected by the property must be properly compensated for the easement.
Okay. So read that again for me. What page is it on? 78? An easement by condemnation, right there, halfway through. It's created under government's right of eminent domain. See, condemnation should trigger what? Eminent domain. Okay. The government's right of eminent domain. The easement is acquired for public use. As with any other condemnation proceeding, the owner of the affected property must properly be compensated for the easement. So when the state took a silver property of mine to put that new bridge in down below my office. They did an easement of condemnation for a piece of my lower parking lot so they could bring the equipment in and work on the bridge. They need a place to work on the bridge. So they came in and said, we're going to create an easement for 3 years. We're going to park our equipment there. We're going to work on building that bridge. I didn't have any choice because the government came in and took it for public use. Now, they gave me compensation for that, but I felt it wasn't enough, so I took them to court to try to get a little bit more. An apparent easement is an easement where one party uses the land of another, right? Is this too redundant? Should I go quicker, Ellen? Yes? Okay. Easement in gross is typically for a utility company. Like when they come through and put power lines. Know that, an easement in gross. The utility company has an easement in gross across both parcels of land for its power lines. I don't know if that picture's in the book or not. How do you terminate? We talked about that. The purpose no longer exists. By merger, by release or abandonment, non-use of a prescription easement. If that guy just quits using it. Okay.
Like if he lets it grow in and you don't have to go back there and cut.
Yeah, if he just quits using it. Lawsuit. Then there's also license. Okay. Somebody give me an example of a license.
You let your friend hunt on your property?
Yeah, you can give him a license for him to hunt on your property, but I don't know if any of you guys have done that. Give me another example of a license. Look in the book.
It's a privilege,
Privilege for what?
or the right granted to a person by a state to operate as real estate broker,
Never look at that.
or salesperson.
Okay, here's a movie. Here's the waterfront down in Lowe's, the theater. We talked about that Lowe's waterfront, right, in Homestead? My wife and myself went and seen 50 Shades of Grey. Look at the back of that movie ticket. What's it say? I took my grandson to the Penguins game, and we parked in the parking lot. That's a license. When you park in a parking lot, there's a 50 Shades of Grey. If you look on the back of it, these movie tickets, parking, Steeler tickets, Penguin tickets, that's all a license for you to use that seat, that parking space, whatever, for a period of time. Anybody read the back where it says, actual says on there, it's a license to use? Yeah. Yeah. Example, park in the driveway. So let's say I had a driveway right here. I can give Lauren a license to use that for a specific time. Why would I give a license versus an easement? I'll take those back. Why would I give a license versus an easement?
Is it just like very temporary?
I can take it off of it. So let's say that Lauren, Ellen owns that lot right there, right? Where that table's at. And Lauren, better yet, let me use Samantha. Here's the road that comes here. Right here. Samantha owns this property, Lauren owns this one. There's a little parking space right here that Lauren doesn't use. Samantha says, hey, Lauren, can I use that parking spot? And these two are friends. So she says, yeah, I'll give you a license to use it. Okay, you draw up an agreement. Okay. Now the reason Lauren may want to use a license, because if she did an easement to use that, wouldn't it run with the land? The license doesn't. So if Samantha moves out and Lex moves into this property, maybe Lauren don't like that. Maybe she doesn't want her to have a license, have that parking space. So if they use their license, she can say no. Just like if you go to a Steeler game and you get all drunked up and you cause a fight, every seat in the Heinz Field is a licensed seat. Okay? So if I give Lexi my tickets and she goes to a Steeler game, gets in a fight, gets thrown out, they can revoke that license. With an easement, you can't revoke it unless you go through the steps that we talked about. So that's good examples of how a license is used. Maybe for a billboard, maybe for a garden, maybe oral should be written. What happens with oral agreements? Get you in trouble, right? In real estate, they have to be written. An encroachment. I showed you that one survey with an encroachment on it, huh? Ooh. Here's another example of a license. Can you pass these out, Andrea? A piece of property that we sold and went, and there was a carport. So this property, this guy here, there was a carport encroaching on his property. So we have a license agreement prepared, giving the owner a right to use that property with a license. And if you read that agreement, there's probably some language in there. So that's just another case. That was okay. Well, we're going to take just a minute here. Hey, Andrew, can you pass some of these other ones? I need some helpers here. Ray? Remember we talked about life estates earlier in the chapter? Here's something Andrea's going to pass out. Ray, you pass out Pete for police power, eminent domain, taxation. Ellen? Pass that out for me. Right of reversion we passed out already for the Bell Vernon School District. And Seneca, can you pass this one out here for eminent domain? So these are just some real life examples for you guys to look at to help it stick a little bit. If anybody has to go to the restroom or smoke a cigarette, now would be a good time to do it. You guys get your foot right here in the mouth. Take 5, guys.
When do you want to do a post?
What's that? we're gonna do a post on social media about this class. So if anybody doesn't want to be in the post, you can leave the room or go in the bathroom. And I think we're gonna step out here, Andrea, and go in. So anybody in this view right here will be in the post. So if you don't want to be on a Facebook post, move out of the way.
You go now, this is right now.
I guess I'll sit there. Yeah, I want the picture.
Let me know when you're ready. So I'm going to get going. I got a whole room full of eager real people who want to get started in a real estate career. What do you want? So we're going to get on with our class. Thank you very much. If you're interested, reach out. And you guys, if you haven't reached out to me and liked me on Facebook, please do that.
Right.
Please do that. And then look at my Facebook page, see if any of my students reached out to me to
Yeah.
like our page and just accept them. And then we also send out a text message yesterday. Did everybody get the text message yesterday? 2 links. My Facebook page, my company Facebook page, and to subscribe to our YouTube channel where you can go. Has anybody went on a YouTube channel yet? Jace, is it helpful? Some of the stuff we have on there?
Yeah, it's all helpful.
It is? Was it?
Yeah.
Yeah. Like if you're driving around, you can listen to it. Or if you're at home and you listen to it before you go to bed. Nothing sweeter to hear Tom Simon's voice to put you to sleep. Right? Okay, let's talk about water rights. Let's talk about water rights a little bit. Hopefully we can get through this unit before lunchtime here. I think we can. Waterfront property has value. State laws govern the use of the water. Okay? So you don't actually own, well, I shouldn't say that. State laws regulate it. So here is a picture of the Gateway Clipper, downtown Pittsburgh. Okay? So they have a right here to use this waterfront property, but they have to follow the laws of the government. They probably had to get permits for the dock along there where they dock the big ships and so forth. Riparian rights. It's land bordering or transversing by a river, stream, or waterway. You cannot interrupt or contaminate the water. If it's non-navigable water, it's split in the middle. So if you look at the page 80, so I want you to remember riparian rights are typically R for riparian, Ellen, R for river. A river does what? Moves, right? Does the water move in a river or stream? So riparian rights would be with water that is moving from this direction to this direction. You got that, Lex? Yeah. So if it's just a creek, a non-navigable stream, so let's say there's a stream right here that runs between these two lots. Don't we see streams? There's little streams and creeks everywhere, right? Those would be what kind of rights? Riparian, right? And the property owner, if it's non-navigable, you can't put a boat in it, then typically the property owners would own to the middle of the stream. Okay? They would own to the middle of the stream. Non-navigable, it's split down the middle. And if you look at that picture with lot A and lot B, and there's a little stream going there, it's split down the middle. If it would be a navigable river, okay, York River, can you navigate York River? Yeah, you can put a canoe or a boat in there. The Monongahela, the Allegheny. If here was two property owners, and this was the Monongahela River, okay, then typically you own to the high water mark, or the, let's see exactly what it says. You own to the edge. Let's dig into that a little bit. Is there a different word? I don't think the high water mark is used for littoral rights. Adjacent to the water. No, it says up to the means average high water mark. So if this is the Monongahela River, they're riparian rights, and Lex owns this lot wherever the means high water mark. It means high water mark would mean kind of like the average. Do you agree with that? Did anybody look up means high water mark in the back of the book? If somebody gets the definition, let me know.
I don't see it back here.
You don't see it? Maybe Google it. Who has Google? Anybody find anything under Google?
Is the peak value not investment?
What's that?
The peak value in an investment?
No.
There's one on the test that says, with 11, unit 5, it says, where is the property line generally located for Pennsylvania's property owners whose land borders like area meet?
The means high water mark.
Yeah.
Okay. Maybe I have a video that'll help explain that. Then you have littoral rights. Okay. Now you're going to remember riparian because R it starts with R for riparian and R for river, right, Dan? Littoral, you can remember LOL, large oceans and lakes. So if you owned property let's say Lexi's property borders Lake Erie. She would own up to the means high water mark. Or in the ocean, if she owned property bordering the Atlantic Ocean, she would own to the means high water mark. That's where her property line would be. I got this video, I don't know if it'll play or not. Let's see. So what do I have to do here, Andrea?
Just do recommended settings. It's just not done.
Littoral water rights. They're usually for large oceans and lakes. So right here, the water rights would be to the means high water mark, which means the most probable high water mark. So right here would be the means high water mark. This property owner would own to here, then the government would own from here on out. LOL, large oceans and lakes, littoral water rights. There you go. Gives me goosebumps looking at that video. I was able to write that whole trip to Jamaica off because of that. Okay. So now let's talk about increases of land by natural forces. Okay, and I hand you one handout. Take a look at it. It says increases of land by natural forces. Exceed. Accretion. I have a hard time pronouncing that. Can anybody pronounce it any better than me? Accretion? Accretion. It's an increase of land. Okay. Accretion. It's an increase increases of land resulting from deposits of soil by the water's actions. Let's say the river goes like this around the bend. Okay, and this guy owns this property right here. Over the years, on the outside of the bend, it deposits soil. And over the years, his property line could move from here to here because he has an accretion. He's getting in his land is becoming bigger because of the deposits. Okay. Alluvion. Newly created deposits of soil, gravel, and sand upon the banks of a stream or river. So that's what this would be called right here. Alluvion. And then you have reluction, and I may not be pronouncing these, my pronunciation is not the best. And that would be if over time the stream or river gets smaller because of the amount of water that's going down it, and then that property line would move from here. If that stream got smaller like this, or that river, to here. So you may want to know those. Write them down. You're going to probably see them on a test somewhere. Let's talk of loss of land by natural forces. Erosion. We all know what that is. That would be the general wearing away of land because of such things as wind, rain, water flow. It's a very slow process. Avulsion would be a very sudden loss of land. Maybe out in California where they have those mudslides. Okay, That would be an example of that. The boundary lines remain the same. The doctrine of prior appropriations. It's used in states where water is scarce, typically out west. The right to use water except for limited domestic use is controlled by the state. Landowners must demonstrate they will use water in a beneficial way. So how many times do you see when they have drought conditions out in California? You ever see on the news where they have water restrictions? And out in California, they have $1 million, $20 million homes, right? And they say you can't water your yard. And every time they do that, and there's a restriction on the use of water, they always find some rich cat that they catch water in their lawn in the middle of the night. Huh? Yeah. So the state can tell you what uses to do with the water other than domestic drinking and using for inside the house. Back out west, back in the day, they would have feuds over the creek that would run down through the farms and maybe split two properties for the drinking water. You can't dam it up. You can't pollute it. You can't alter the way it goes, without a permit from the state. Okay, let's talk about leasehold estates. What did we call this video, Andrea?
Encumbrances.
Can you stop it? And restart it. We'll call it leasehold estates.
Are we doing that one?